take a pardon, my lord, extension of the interim bail, if possible, tomorrow.
No, is it a single bench?
No, division. Well, in custody about 10 years.
It's two criminal appeals. One, there is a custody period of more than 12 years. One, custody period more than 10 years, my lords.
Well, the appellant was custody in more than 11 years, or
May it please your lordship. This is a PL matter, my lord. This matter has been assigned by the Honorable Chief Justice to this Honorable Bench, my lord. Matter relates to non-availability of drinking water, my lord, in some parts of the state, my lord. This notice has been issued, counter and rejoinder has been filed, my lord. May I pray, my lord, let this matter be listed before vacation, my lord. See that, please file. Again, before, except, my lord, 17, my lord. Any date. There is acute drinking water problem. Oblige, my lord.
Supplemental list, item number 1.
May I please your lordship? An appellant before your lordship is the husband. He has been convicted under section 302 by 34 of IPC. And
Is bail for only appellant number 2.
to husband, your lordship. Others was granted bail, your lordship. And I am inside custody since 2015, your lordship. I was on bail during trial.
When the judgment was pronounced.
23/12/2015.
Since that day you are in custody. You have never been released on interim bail even.
No, man. I was on bail during trial, your lordship.
Name is Gokula Bisoi. What are the offenses under which you are found guilty? And
302 and 304B, your lordship. 304 to the life or 304 10 year.
.498 also you are found guilty. RI for
1 month.
1 month under section 1, so concurrent sentences. So when your marriage was solemnized with
4 years back before the incident, your lordship. Incident happened in 19/5/2009.
1905?
2009. 4 years.
4 years prior to that, there was marriage. What is the name of the deceased?
Name of the deceased also.
Meenakshi.
Huh?
Meenakshi, my lord.
Meenakshi Pradhan.
Any issue out of wedlock?
No issue.
What is the cause of death as per the
burning injury, your lordship?
They survived for some days or died?
No.
Died immediately. So no dying declaration.
No, there is a dying declaration before PW3. PW3 is the independent eyewitness, your lordship.
What she has stated?
Your lordship, kindly PW3.
No, dying declaration before PW8, my lord, auntie.
3
PW8 also and PW1 also and PW3 also.
May read.
Yes.
Lordship, para 2 ta poduchi. On 3/4/2001 in the morning hour 7 a.m. while I was working in the field of Arjuna Khattai informed that accused persons have burned your sister. Getting such information, immediately I rushed to the house of the accused. I found the sister, deceased Meenakshi, was sleeping outer veranda house focused being covered with two napkins. I brought her to the hospital in a auto rickshaw. And while I was bringing her to hospital, I asked her about the reason of reason. The deceased Minaki disclosed me that accused persons tied her hands and legs and then poured kerosene uh, and mobile upon her and set fire. Getting such fire, he sustained severe burn injuries. Your Lordship, kindly see the uh, version of PW9.
He is also a witness to the dying declaration.
Again.
Yes.
Para 2. About 2 years back of the incident place, one day while I was on my cultivated land, my wife sent a boy to come immediately giving me information him that Minaki has sustained burn injuries. So immediately I came and rushed to the house of the accused persons. Thereafter, we took Minaki to Baripada Hospital in an auto. When the doctor of Godipada Hospital referred to DHS Nayagarh, we brought her from the for better treatment to DHS Nayagarh. She got treated in the Nayagarh Hospital. After she got some treatment in DHS Nayagarh, she regained her sense and being asked by police in my presence, Minaki disclosed that the accused person tied her hands, gagged her mouth, and poured kerosene, set fire. I also examined in this way. So one is saying in the auto, second was saying and he never disclosed anything in the auto. He was also accompanying in the auto, but before the police. Police said that they never stated these things before me. Lots of kindly the PW 11 is the investigating officer. He stated that it is a fact that PW3 is the who stated that on the auto he stated all these things.
Who is the IO?
IO Huchi PW11.
You are placing the contradiction part.
Contradiction part.
PW11, which paragraph?
Paragraph 8.
Yes.
I have examined Chaitanya Swang and he recorded his statement on 161 CRPC. It is a fact that PW3 Basanta Swang not stated before me, Arjuna Khate informed me about the killing of his sister by the accused. It is a fact that PW3 has not stated before me that the time of his arrival in the house of the accused person, he found none of the accused persons were present in the house and the body of the deceased and none of them even accompanied the deceased to Niagara Hospital. It is a fact that PW3 has not stated before me the accused persons burned Minaki by pouring mobile.
Even if PW3's evidence is not there, but you just place the evidence of PW9 he has stated.
PW9 टाकू कोर्ट निजे डिसबिलीव करचंदी. Paragraph 9 of the judgment, Your Lordship. On the next, Law and Defense Council submitted that the offense of 302 of IPC is not made out against the accused person. Die declaration is not believable and acceptable. It appears from the evidence of PW3 Basanta Kumar Sahu that on getting information, he immediately lost to the house of the accused, found the deceased Minaki was sleeping outer veranda of the accused persons being covered with two napkins. He brought out the victim Minaki in an auto rickshaw to the hospital.
Witnesses to the dying declaration.
Right.
One is PW3, the other is PW9.
9.
PW9 has been disbelieved by the trial court.
9.
So far as PW3 is concerned,
he
has stated before in the court about the dying declaration, since it is not there in the 161 CRPC statement that has been proved through the IO. That is your submission.
Well,
what about the other co-accused persons who
others are granted bail, Your Lordship,
in this appeal?
in this appeal.
What do you
For
say?
PW8 also dying declaration is there, my lord. The aunt of the deceased, my lord. 1893. Each of the witnesses corroborated each other.
One has not stated anything.
One have stated, my lord.
One hostile.
Informant.
One hostile ହେଲା ପରା।
Again, my lord, PW 8, my lord.
ଆରେ ସ୍ଥିର କରି କୁହନ୍ତୁ PW1 ଆପଣ କହିଲେ
One time informant, my lord. 8 PW 8, my lord. Supported the prosecution case, my lord. Para 1, my lord.
PW8 is a witness to the dying declaration.
My lord. The second page. On being asked on the second page, my lord, 27.
I came to Nayagarh Hospital, made the Meenakshi.
My lord. Thereafter,
There, Nayagarh Hospital, on being asked, Meenakshi replied that accused persons tied hands and legs and poured kerosene, so and so. So, if this version is accepted, then all the accused persons who have been enlarged on bail by this court
my lord.
and this petitioner, they are similarly situated.
Present petitioner husband, my lord.
Husband, je ସମସ୍ତେ ନାଁରେ ସେ
And
କହୁଛି।
not before the 4 year of marriage. In fact, marriage 3 year back, my lord. Marriage solemnization on 19/5/2009. Occurrence happens on 3/4/2011, my. Before 3 year back.
Even in the cross examination, this witness PW8, in page number 3,
My lord.
stated that by the time we arrived at Godipada Hospital, प्रथम आगे Godipada को गले,
My lord.
the condition
Yes.
that is 1, 2, 3, 4, 5, 6 lines from the top of page 3,
My lord.
PW8's evidence. By the time we arrived at Godipada Hospital, the condition of Meenakshi was serious. Seeing such condition, doctor of Godipada Hospital referred her to DHS, and at that time she was referred to DHS by Godipada doctor. She was unable to talk. Her face was completely burnt, and she was not in sense. After she was given treatment for some time there at Nayagarh Hospital, she was referred to SCB Medical College, Cuttack. As her both hands and legs were burnt, there was so and so. So all these things are there. It is to be, of course,
IOV କହୁଛନ୍ତି I requested DMO of the DHS Nayagarh for reporting that of the recording the statement of the victim. The ADMO refused to record her statement as the patient is unable to talk and in an unconscious condition.
କିଏ କହୁଛନ୍ତି?
IO.
କେତେ number paragraph?
2 number paragraph.
Paragraph 2.
2. Then I issued injury requisition.
କୋଉ line ଟା କହୁଛନ୍ତି?
Second part.
ଆଚ୍ଛା ପ୍ରଥମ second page ରେ
Again.
I requested the ADMO of DHS Nayagarh for recording the statement of the victim, but the ADMO refused to record her statement as the patient is unable to talk and is unconscious condition. So जोठी आपणकर साक्षी कहूची dying declaration देला बेली जो साक्षी को आपण रिलाय करछन PW8
My lord.
सेठी आसुची जे ADMO ता कंडीशन देखि किनी कहले से अनकॉन्शियस अछि कथा कोई पारुनी तो तार डाइंग डिक्लेरेशन रेकॉर्ड ही पारलानी आपन 8 नंबर साक्षी केमती सुनी देला सब
The hospital, the
PW8
yes, 77.
Just after occurrence.
just wait, please.
It came to Nayagarh Hospital.
Read it, please.
Is second.
More for second page. We get a direct LC at the
It came to Nayagarh Hospital. There at Nayagarh Hospital, being asked by me, Meenakshi replied that accused person tying her hands and legs poured kerosene
Cross-examination. Maybe it has been stated to the court. 78. The next page. 78. It like, by the time we arrived at Kopi Pada Hospital, the condition of Meenakshi was serious. Seeing such condition, doctor advised referred to her to DHS. At that time, she was referred to DHS. She was unable to talk. Her face was completely burnt. She was not in sense. Cross examination unable to talk जोटा कि यार ADM रो मध्य same person. Are the learned counsel for the petitioner, learned counsel for the state. This interim application has been filed by appellant number 2, Ukulo Bisui, for bail. Learned counsel for the petitioner submitted that petitioner is the husband of the deceased, Meenakshi Pradhan, and he was on bail during trial. And after pronouncement of the judgment on 23/12/2015 is in judicial custody. Learned counsel further submits that marriage between the petitioner and the deceased was solemnized 4 years prior to the date of occurrence, which took place on 19/5/2009. And the only material available on record is the dying declaration of the deceased before 3 witnesses, that is PW3, PW8, and PW9. Learned counsel argued that PW3, though has stated about the dying declaration being made by the deceased while she was being shifted to Noyagarh Hospital in an auto rickshaw, but it has been confronted to her and proved to the investigating officer, Secretary PW11, that he has not made any such statement regarding dying declaration of the deceased in his statement under section 161 CRPC. Land Council submitted that so far as the PW9 is concerned, the Learned Trial Court has disbelieved his evidence, and PW8's version that the deceased made dying declaration before him at Noyagarh Hospital, before her, at Noyagarh Hospital is full of contradictions. Is contradicted during cross-examination, and it appears from the evidence of the IO bracketary PW11 that though he requested a DMO of DHS Noyagarh for recording the statement of the deceased, but the ADMO refused to record her statement as the deceased was unable to talk and he was in an unconscious condition. Learned counsel further argued that there are good chances of success in the appeal and balance of convenience is in his favor, and other accused persons have already been enlarged on bail, and though paper book has been prepared, there is no chance of early hearing of the appeal in the near future, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, placed the evidence of PW 389, PW 11, and doctor कितने number से की?
PW 11 my lord.
PW 2. PW
No, I know PW 11. Sorry my lord.
PW 2.
PW 2.
and PW 2, the doctor who conducted post-mortem examination. considering the submission made by the learned counsel for the respective party, nature of evidence adduced during trial, the period of detention of the petitioner in judicial custody, fact that the petitioner was on bail during trial, absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail.
Obliged.
Item 2.
Yes.
May I please, Your Lordship? Your Lordship, may kindly visualize order dated 29/11/2017 passed by this.
29/11/2017.
My By that order, Your Lordship, the appellant number 2 was granted bail. And so far as the petitioner number, appellant number 1, Manas Mahapatra is concerned, we direct the state to produce the psychiatric evaluation report from the Mental Health Institute, SCB Medical College and Hospital, Kotak, within a period of.
Now, this bail application you have filed for appellant number 1.
Appellant number 1 and 2. 2 was granted bail.
Granted.
Yes, sorry, my lord, appellant number 1. Yes.
Oh, that was allowed for appellant number 2. So far as your is concerned, it was kept pending.
And direction was given, my lord, to the state to produce his psychiatric evaluation report from the Mental Health Institution.
Now, how many years you are in custody? What is the date of custody?
Custody, my lord, from the date of occurrence.
Final form that you have to report. What is the name of this appellant?
Manas
Mahapatra. Manas Mahapatra custody date hoji 12/4/2012. Appellant number 1, 12/4/2012. And you are never released on bail during trial?
No, my lord. What has happened, my lord, pursuant to this order passed by this honorable court, the first time it has come, even if several attempts have been made. But the report has not come. There is a direction that unless the report comes, it will not be listed. Later on, there was a direction. So after 7 years, the report has come.
Instruction only dispute, my lord.
No, he was not on bail. Okay. So, what is the conviction and what is the sentence? A judgment that you have. Yes, Mr. Mahapatra. What is the conviction? 302/34.
302.
Life imprisonment.
Yes.
Right. So,
both the convicts to undergo imprisonment for life and to pay a fine of.
what is the date of occurrence?
11, my lord, 11/4/2000.
11/4/2012. What is the name of the deceased?
Vishwanath Naik.
Huh?
Vishwanath Naik.
Vishwanath Naik. Eyewitnesses are there?
My lord.
Who are the eyewitnesses?
PW 17, 18.
17,
18 and 19.
PW 18 and PW 19 eyewitnesses.
18 and 18.
And with the doctor who conducted PM examination?
PW 15.
15.
My lord.
15. Let us come to PW 15 first, see how many. What is the weapon of assault?
Ask my lord.
Pottery, lordship.
How many blows you have given? 1, 2, 3, 4, 5, all are inside. Temporal region, neck, right pinna. So
She is a psychiatric patient, Your Lordship.
17. ওষুধ খাওছেন বলে লেখা আছে। Content graph seems also referring to this. PW 17 ତ କାହିଁ କିଛି କହୁନି ସାକ୍ଷୀ ଆଇ ୱିଟନେସ୍ ବିଷୟରେ କହିଲେ informant shouted to me to go to her, my brother has been assaulted so and so. At that time in my place, acha, I have seen cutting his hand, leg, acha. 17, then 18.
19 also the eyewitness and daughter of the deceased, my lord. Two son was killed by the father, my lord.
So practically he's in custody since for more than 12 years. Are the learned counsel for the petitioner, learned counsel for the state in pursuance of the order dated order ta kohutile jo magaitila
My Lord, that is order dated, Your Lordship, 29/11/2017.
29/11/2017. The learned counsel for the state has produced the report from Superintendent District Jail Puri, which indicates that the day-to-day behavior of the petitioner, that is appellant number 1, Manas Kumar Mahapatra, is very silent. He performed, he was performing his day-to-day routine work in a systematic manner. His food habits, so on. So এটা যাহা আছে লিখে দিও না, কোট করে দিও পুরা entire যাহা আছে সে না। The learned counsel for the petitioner submits that the petitioner is in judicial custody since 12/4/2012, and as such he has completed 12 years imprisonment, and paperwork has not yet been prepared, therefore there is no chance of early hearing, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, placed the evidence of 3 eyewitnesses, that is PW 17, PW 18, and PW 19. She also placed the evidence of PW 15 from the doctor who conducted post-mortem examination over the dead body of the deceased Vishwanath Naik and noticed number of incised wounds on different parts of the body, and according to the doctor, the cause of death was due to shock and hemorrhage, and mainly due to the effect of injury number 2, which was on the right side neck. Considering the submission made by the learned counsel for the respective party, nature of evidence adduced by the 3 eyewitnesses, nature of injury sustained by the deceased as per the evidence of PW 15, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody for more than 12 years and absence of any chance of early hearing, we are inclined to release him, and keeping in view the ratio laid down in the case of Letty versus Swanson, we are inclined to release him on interim bail for a period of 3 months, and report to be called for by that from that IAC. Okay. Yes, redouble activity. That there is another application for stay of realization of fine that is allowed. Yeah.
Item 3.
May I please allot the
Yes.
May I please allot.
How many appellants are there?
One, my lord, the appellant faced the trial for the commission of the offence under section 498A, 304B, and
I have
30.
filed my appeal on it. I have appealed that case.
Ah,
I have appealed in that case.
associates on behalf of the appellant. आगुर अपन किए थिले कि First-
I filed ILRC.
ଆଗରୁ ବି ଆଗରୁ ଫାଇଲ ଥିଲା ପେଣ୍ଡିଂ ଅଛି।
No, who filed the appeal?
On behalf of S.C. Porijas.
Srinivas Parija.
Srinivas Porija.
Srinivas Parija and B.R. Dalai filed the appeal.
Yes, sir.
It is a case of single appellant.
Single appellant.
Then Mr. Sahu, you filed the Vinama
My lord.
without the consent of the
Instruction filed, my lord. Take instruction, let it come next week.
Before that, you should have taken the consent. He is come ready to argue the matter. If prisoner's petition would have been there, there is no problem. But
Yes, that thing somewhere misplaced or something. My lord, take instruction. Let's see. Also after I have filed ILRC also.
IA is pending, my lord, in our application. 659.
PCରେ କନେକ୍ସନ ଦେଇ ହବ ବର୍ତ୍ତମାନ କୋଉ ଜେଲରେ ସେ ଅଛି
କେଉଁଝର ଜେଲରେ
କେଉଁଝର ଜେଲରେ କହିଲେ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ କେଉଁଝର ଯେତେବେଳେ ପଚାରିଲ ହଁ okay, we are passing it over. It's possible.
Item 4.
R.R. Pattanaik is requested.
Please use the mic properly.
Mr. Bhattacharya has requested this matter,
JCRL 15 of 2018. How many appellants are there?
Single appellant.
Rai Singh Purti.
Pardon?
So it is mentioned that Mr. Pradeep Kumar Pradhan and associate filed Bhinama without taking consent. So you are appearing for
Mr. Bhattacharya, R.R. Bhattacharya, his power is there.
Bhatta?
R.R. Bhattacharya, his power is there.
Where?
The Vaklatnama, in the file.
ଶୁଣନ୍ତୁ ପ୍ରଥମେ ସୁନିତା ବିଶ୍ୱାଳ ଫାଇଲ କଲେ ତାପରେ ଆପଣଙ୍କର ତାଙ୍କଠୁ କିଛି କନସେଣ୍ଟ ଭରିଆ ନେଇନାହାନ୍ତି
Item 5, my lord.
Sorry.
This one is item 4, my lord. So Jafrullah mentioned for item 5.
We are in item number 4. Sunita Biswal, then Pradeep Pradhan and so on. अच्छा पास ओवर देखियो कौन है Yes, next matter.
Yes. Item 5.
Well,
Yes.
Let
Single appellant, no?
Pardon?
Single appellant.
Single
My lord.
Nilu alias Pramod
Kumar
Kumar
Swine
Swine.
convicted under section.
Yes.
But he, along with two others, faced trial for charge under section 449, 302, 212, 34 IPC. All acquitted from other two acquitted from all charges. And this appellant is also acquitted from charge under section 212, 34 IPC, but convicted under section 449 by 302 IPC.
Mr. Jafrullah, prisoner's petition has been received at flag B, and that is the latest one where he has stated that मुक्त केस परिचालना करिया पई वकील भाବରେ श्रीयुक्त राधिका रंजन भट्टाचार्य को नियुक्ति करियछि वर्तमान तांको सहित नूतन भाବରେ श्रीयुक्त महिमा स्वयं को मोर वकील भाବରେ नियुक्ति करिया पई अनुरोध करू या रहिछि तांको सहित अछि ऑफ कोर्स तांको सहित ऑल राइट अपन प्रेस करंतु कोन you are found guilty under what offense
449 by 302 IPC
judgment of it.
and life in both the mallet. He is convicted in both the count mallet. He is convicted.
Just a minute, let us see that. So, what is the name of the deceased?
Sumitra Lenka.
Huh?
Sumitra Lenka.
Sumita.
Sumitra Lenka.
Sumitra
My lord.
Lenka. Date of occurrence?
17/6/2013.
So, whether the appellant related to the deceased or what?
Pardon?
Appellant related to the deceased or not?
No.
Any eyewitness to the occurrence?
No eyewitness to the occurrence.
Then?
Nasin, my lord.
Case circumstances.
What are the circumstances?
Circumstances, paragraph 7. Paragraph 7, internal page 5 of the judgment.
5. Strong motive of the accused, namely Nilu Swine, to kill the deceased due to launching of prosecution of a rape case against him. Nilu Swine was threatening the deceased again and again to murder unless a rape case. What is the status of that rape case?
That case is ended in conviction. Now 4 years conviction. That he has already suffered 10 years. But the case is that in 2011 there is an allegation that while the informant with the son of the here is also he is the informant. Alleged that while both the husband and wife are sleeping, this appellant has committed rape. So the allegation that thereafter, after being released on bail after 8 months, he was threatening this the informant and family members that you have made a false case and you withdraw this case, otherwise I will kill you. That is the motive that has been enumerated. And thereafter in 2013, when on the date of occurrence, allegation informant is said that when the date of occurrence when he and his wife had been to their relation's house and her mother was there, he got information that her mother was killed. Thereafter he came and alleged allegation against that my mother has also been raped and murdered. Accordingly, FIR was registered on 457, 376, 302 by 34.
No, this circumstance number,
my lord,
3 and 4 particularly,
my lord,
your presence near the house of the deceased at the relevant night of occurrence, and also you are seen entering into the house.
That
PW1 has stated,
my lord,
that accused in absence of Ritu Lenkar, so and so, accused nearly had entered into the house of the deceased. Date of occurrence dina seta gote baki threatening hariga rahuchi.
These are the two important circumstances.
What is the date of custody?
2/8/2013.
2/8/2013 halle 11 years pakabhi 10 years kete mas hoche.
And the entering kariba jo circumstance de he is a witness. He is if you will see the evidence, he is a witness to inquest. he turned hostile. And inquest, he made a different in the inquest report also. He did not tell us regarding this appellant that he had. I'll go to a line. PW.
Motive is there.
Motive, only motive has been. That is why
she was a witness against whom you have allegation that you have committed rape on
of
her
daughter-in-law 2 years back. So that is the motive. That is why, and he was threatening. That is why that case. That is the strong motive that is entered in trial court has taken note of that. And the circumstance regarding PW 1, who has stated regarding that he was entering, he is a witness to inquest. In fact, he turned hostile and inquest report. He made he did not named me also. Nothing.
No, that's a different matter. PW1 evidence that you are seen entering to the house in the midnight and the dead body was found inside that house with so many injuries. That is there in the judgment in paragraph number 15, page 14. And
that is my only comment. The evidence also, the relevant parties on 17/6/2013, Neelu Swai was in absence of Ritu Lanka and her husband accused Neelu Swai enter into the house of Sumitra. Actually, Neelu Swai had told me near our Panchayat office that he would murder Sumitra.
Threatening ଦେଇଥିଲେ ଏବଂ ତାକୁ କହିଥିଲେ ମଧ୍ୟ ଅନ୍ୟ ଜଣଙ୍କ ପାଖରେ ଯେ ଆପଣ ତାକୁ ମାରିବେ।
ସେଇଟା ଖାଲି he is a witness to inquest.
Motive, entering into the house, giving to the will kill, all these things are there. Apart from number of injuries were there, and the weapon was recovered also.
Weapon is from the spot. Nothing at this instance. No.
11 years. The London Council for the appellant submitted that the appellant is in judicial custody since 2/8/2013. After going through the impugned judgment, I think it proper to call for a report from the IAC of police station at Jajpur police station about the criminal antecedent, if any, against the appellant. So also whether there is any possibility of law and order situation in the area in case the petitioner is released on bail. Put of this matter after entering summer vacation 24th June. Free copy of the order be handed over.
Item 6.
Yes, अच्छा इटे वोटे दस्त बता छाड़ दीजिए। The billing assistant point out कला। The billing assistant has pointed out that on page number 109 and 110 of the judgment, dated 6/5/2024. Inadvertently, the signature as now is missing. Complied the page was at page number 10 to the signature. Those pages. How confident? It's a theater. How would a compose of sound close? But we can. There is an order to
Item 7.
Seven, prisoner's petition at flag B, R.K.Pattanaik also filed. Prisoner's petition ने कहा को request करছে अशोक सरांगी ठीक है outside তাদের kitchen দেখি যাও बिना पानी त्रिपाठी ना कटियो peruse the prisoner's petition at flag B, in which request has been made for engagement of Ashok Sarangi and Akshay Kumar Sahu as his advocate, Mr. the Land Council, Mr. Sahu, and here color now filed. Mr. R.K. Kumar Sahu has filed green, which is accepted. The name of Binapani Tripathi shall not be reflected in the cause list henceforth. Yes.
Item 8.
My lord. Here the
Business person आपनो ना चाहिए ना.
yes, madam.
Flag B, चित्तरंजन साहू को निकलना
Yes.
ठीक है. B नामा flag कर दीजिए आप.
My lord, in this case, initially by the order dated 29/7/2019, I was appointed as the amicus curiae in this case. I have got no objection if my learned friend takes care of this case.
Peruse the
Prisoner's petition there. On that basis, I was appointed. I have got no objection if my learned friend takes care of this.
For engagement of Mr. Chittaranjan Sahu as advocate. Mr. Sahu has also filed Inama, which is accepted. Henceforth, the name of Mr. Chittaranjan Sahu and his associate shall be reflected in the cause list. The other names, that is so and so, shall not be reflected in the cause list henceforth. Yes. अच्छा आपको को डेट रे एंगेज कराइतला अच्छा
On 29/7/2019.
पीके राउत रहे Lenin amicus curiae was engaged on 29/7/2019 is present in court and submitted that he has no objection relating to the engagement of Mr. Chittaranjan Sahu as the advocate for the appellant. Yes.
I may be permitted to hand over the brief given to me.
Mr. Rautray handed over the brief which he has received from the registry. Mr. Sahu. Yes. Next.
Item 9.
But the appellant has been convicted.
Sole appellant or
Sole appellant.
item
This is a
number.
case under section 121, madam.
121,
Like
121A.
The DRDA matter, my lord, the Baleshwar, my lord. The appellant was
My conviction
was,
is solely based on the
transmitting the
interrogation
secret
report.
of the government, my lord, to the Pakistan intelligence, my lord,
So
regarding the measures and the testing of
have
the
you that Chandipur?
my lord, Chandipur.
So you obtain the criminal antecedent instruction and also that we'll see that after summer vacation.
Item 10.
The Learning Council for the state took some time to obtain the criminal antecedent against the appellant. Out of this matter, we commenced from 24th of June 2020. Yes.
Item 10.
Item 10.
My lord. My lord, here is a case, my lord, live conviction under section 365 and 364A.
Sole appellant.
My lord.
Okay, let us see the judgment.
My lord,
364A, life imprisonment.
365 and 364A, my lord,
364,
conviction,
acha.
my lord. Ordered by the Assistant Session Judge Kendrapada, my lord. My lord, actually, my lord, 4 persons, including the appellant, were facing the trial, my lord. And 3 other were charged under section 363, 365, 364A, 368, read with 34, my lord, for kidnapping of the minor victim.
What happened to the co-accused persons?
My lord, they have been acquitted, my
They
lord.
have been acquitted.
So this appellant also acquitted in other offences, whereas convicted under section 365 and 364A. My lord, at best it is a case of 365, my lord. In worst case, my lord.
So, on the basis of whose evidence you have been found guilty?
My lord, actually, my lord, entire case, my lord, roaming around 3 evidences, my lord.
Hmm.
Father, mother, and victim, my lord.
Who are they? PW?
My lord, PW1, PW2, and PW8, my lord.
PW1, PW.
My learned friend may supply me the copy of the
Oh,
deposition.
you have not supplied the acha. All right. Mister, you do one thing. You collect it in your pen drive. We are providing you. The Learning Council for the state submitted that he is not having the deposition copies with him. Let the registry supply the deposition copy to the Learning Council for the state in his pen drive. Upon so can you get ready by tomorrow or will it take up after next week?
Next week, I don't think that my lord is there.
All right, 20th of May 2024.
20th of May, my lord.
Huh?
My lord.
Are you not present on that day?
My lord, I am coming in Walker, my lord. I have suffered, my
You
lord.
argue from the through virtual mode where you are coming. If you are feeling uncomfortable and feeling pain, you can argue the matter through virtual.
All right, your lordship.
Or you want it after summer vacation?
No, my lord.
It is up to you. You can argue.
कम लिस्ट भीतर के आसिले केमती स्पेसिफिक एडजमेंट करी कम लिस्ट भीतर आसिले
20 तारीख दिन तो निया जीवो सब मैटर तो पढु 20 तारीख 25 2024
Item 11.
Mr. Tripathi, you collect
Yes,
it,
sir.
just give your,
Will do.
it can be given immediately. Yes, item number 11, Mr. Sahu.
May I please? The appellant has been convicted for the offense under section 302 and 307 of the Indian Penal Code, sentenced to undergo RI for life and fine of rupees 2,000 for the commission of offense under section 302.
Just a minute. Let us see that judgment part. Okay. Single appellant.
Single appellant.
Okay. So 302 life imprisonment, 307 5 years, 1,000 fine. What is the name of the deceased?
Name of the deceased, my lord.
Uh, informants, we are asking you the name of the deceased.
Sunna. S-U-N-A.
Kunna, K-U-N-A.
S-U-N-A.
Oh, Sunna. Date of occurrence?
Date of occurrence, my lord, 9/10/2013. 8/10/2000, interval night of
K-U-N-A.
Kunna.
Sunna, S-U-N-A, my
In the judgment, it is mentioned as Kuna. Kuna tarki likha hai.
lord. But in the deposition, it was mentioned that S-U-N-A.
Let my lord and friend also supply me the copy of the deposition.
Then you go through the same order.
Well.
It will be listed on 20th of May. Same order. The pen drive will provide and it will be registered to supply the deposition copies to him. Matter to be listed on 20th of May 2024. Like Mr. Tripathi submit that he is not having the deposition copies with him. Let the registry supply in the pen drive. Yes. Who matter?
Item
3. Council ଅଛନ୍ତି? गरिला मनोहर राव फेस देखा जाऊनी एडजस्ट करूँ
कैमरा
एडजस्ट करूँ
आड़े आगु आसे कोंदु
हाँ
आउटे आगु डाकंदु आउटे कैमरा एडजस्ट करनो उठिके
ये आपण जो अपील टी दाखल करछंती हाई कोर्ट रे आपण प्रथमे श्रीनिवास परिजा और दळई को देइथिले चित्तरंजन साहू आउ माधव लता दास एमाने वकालतनामा परे फाइल करछंती आपणकर वकील हिसाब रे से आपण काहाकू वर्तमान केस परिचालना करिया को दबा को चाहूचंती
चित्रांग साहब दे आई छे ना
अच्छा ओके ठीक है हो since Mr. Srinivas Parija and B.R. Dalai filed the appeal and Mr. Chittaranjan Sahu and his associate filed B-Nama subsequently in this case without taking consent from the previously engaged counsel. We asked the learned additional government advocate to give intimation to the jail superintendent of district jail Keonjhar to make the appellant available for ascertaining whether he intends to engage to whom he wants to engage his counsel. The appellant appeared through virtual mode from the district jail Keonjhar and submitted that he intends to engage continue Mr. Chittaranjan Sahu as his advocate. In view of a statement made by the appellant, henceforth Mr. Chittaranjan Sahu and his associates shall be the advocate for the appellant. The name of Mr. Srinivas Parija and B.R. Dalai shall not be reflected in the cause list henceforth. You can argue the matter, Mr. Sahu. You have given the deposition copies to the house. Soon without the case. 302 की असुविधा ना. CRLA 659/2017 Gorilla Monohar Rao. Yes, what is the conviction and what is the sentence?
722 IPC lordships. So
Ah.
for life, my lord.
Okay, and since when you are in custody?
14th April 2016.
Please use the mic properly.
14th 16, my lord.
14th
April 2016.
14/4/2016.
My lord.
You are not released on bail during trial.
No, my lord.
So it is 8 years you have completed. What is the name of the deceased?
This is my Sirisa. Sirisa. Sirisa.
Sirisa.
My lord.
Date of occurrence?
Yes, my lord. 12th April 2016 lordships.
12/4/2016 ରେ ଘଟଣା ହେଲା. Eyewitnesses are there?
No eyewitness lordships.
No eyewitness.
Only last scene theory, PW4, my lord.
So circumstantial evidence is last seen.
Yes, my lord.
Where that circumstance has been?
PW4, my lord, the owner of the house, my lord.
PW4. What is the relationship between the appellant and the deceased?
Husband wife, my lord.
Husband wife.
Yes.
Achha.
And doctor is my lord PW7.
Doctor is PW7. So what PW4 has stated?
PW4, my lord, I'm permitted lordships.
Please adjust the mic and.
My lord. I know the deceased, I do not know their father. I know the accused standing the dock, the accused and deceased. Wife was residing in my house. Rent for 2 months in February and March 2016. This incident took place in the month of April of Tuesday. By that time, they had not left my house. In the evening by 7 p.m., I was watching news in the television. I heard crying shout. I rushed to the rented house of the accused and found the accused was crying by keeping the deceased on his lap. I guess that deceased might have suffered from sunstroke, so I advised him to take the deceased to hospital immediately for treatment. He immediately took the deceased to hospital, my lord.
Okay. Then what the doctor has stated? PW7.
Yes. PW7, my lord.
Bruise with superficial abrasion on the chin. Next is another bruise abrasion in the so internal fracture. Dissection of the neck, it is found that there is congestion of so and so. Okay. Postmortem. Feature of asphyxia. Injuries are more towards homicidal in nature.
Well, kind of gone through the cross-examination by defense lordships.
Hmm.
Doctor, para 2.
Please read it out.
Yes.
In my postmortem report, I have mentioned that the deceased, namely Sirisa, is the daughter of so and so. I noticed both the thumb imprints and the center of the neck below the chin. It's a fact that fingerprints appears on the either side of the windpipe in case of throttling. With heavy pressure applied on the so and so. In the instant case, I have not noticed the fingerprints on either side of the window. Sure. It's a fact that sufficient pressure on the windpipe is required to cause death. In case of adult, when sufficient pressure is applied on the neck structure, usually there is chance of fracture of thyroid cartilage, required cartilage hide bone. एवढा कौन किसी देखा हो नथला बोन फ्रैक्चर नथी लगी नेक रो internal structure कौन देइछि internal examination on dissection of the neck it is found there is congestion acha so on dissection it was found that the injury was limited to It was antemortem nature. Thyroid cartilage so are intact. Oh, acha. So, Mr. Das, madam, ଏଗୁଡ଼ା ସବୁ intact ଅଛି ଆପଣଙ୍କର? ଆପଣଙ୍କର କେସ୍ ନୁହେଁ ତ କୌଣସି ରସି ଫସିରେ ତଣ୍ଟି ଚିପିକିନି ମାରିବା ଯଦି ଇଏ ହୁଏ?
Yeah, যেটা কইছে in the case of the hand, there is no bleeding from mouth, ear or nose.
ପଛପଟେ ସିଏ କହୁଛନ୍ତି
When the thumb or fingerprints are noticed on the neck, it should be photographed before the conducting procedure.
ପଛପଟେ କିଛି ଇଏ ନଥିଲା ସେ କହୁଛନ୍ତି ଆଗ ପଟେ କେବଳ ପ୍ରେସର ମାର୍କ ଥିଲା ଇଏର ଥମ୍ବ ର ଥିଲା ଦିଟା ଥମ୍ବ ର ପଛପଟେ ନଥିଲା ବୋଲି କହୁଛନ୍ତି ଇଟ୍ ଇଜ ଅଲସୋ ପସିବଲ ଯଦି ଇଏ ରହିଯାଇଥିବ ବାଳ ରହିଯାଇଥିବ ଗଣ୍ଠି ଯୋଉ ହଁ ସେଠି ହୁଏତ ନ ଆସିପାରେ ବଟ୍ ଏଗେନ୍ ଫ୍ରଣ୍ଟ ରେ ପ୍ରେସର ଦେଲେ ଏଇ ଜିନିଷ ଗୁଡାକର ଫ୍ରାକ୍ଚର ହବାର ସମ୍ଭାବନା ବହୁତ ରହିଛି ସେଟା ବି କହୁଛନ୍ତି there is chance of swans. What is the motive behind the commission of the crime? They are husband and wife staying together in the rented house. Anything that why she would kill?
Because the father of the disease, mother of the disease hostile man.
ହଁ କେବେ ବାହାଘର ହେଇଥିଲା ତାଙ୍କର?
ବାହାଘର ମାନେ exactly date is not known, my lord. 4 to 5 years back, Lord, seems.
ବାପା ମାଙ୍କର evidence କହୁଛନ୍ତି 4 to 5 years back.
My lord. And they are declared hostile, lords.
So no motive has been established.
But PW4 in cross-examination created, my lord. I have never seen them quarreling, my lord.
ତାପରେ continue କରିଦେବେ. The learned counsel for the appellant submitted that the appellant is in judicial custody since 14/4/2016 and as such he has remained for 8 years in judicial custody. The deceased Sirisa was the wife of the appellant and the occurrence in question took place on 12/4/2016. The marriage between the petitioner and the deceased was solemnized 4 to 5 years. 4 to 5 years prior to the date of occurrence. He submits that there are no eyewitnesses to the occurrence. The case is based on circumstantial evidence. The prosecution has not proved any motive behind the commission of crime. The parents of the deceased has not supported the prosecution case. The main evidence is the last scene which is stated by PW4, the landlord in whose house the petitioner and the deceased were staying on rent for 2 months prior to the date of occurrence. And PW4 has stated that when he came to the house of the appellant hearing cry, he found that the appellant was crying, keeping the deceased on his lap. However, he has stated that there was he had never seen any quarrel between the two. Right. The learned counsel further submits that the evidence of the doctor bracketed PW7 who conducted post-mortem examination over the dead body, that it's a homicidal death is not acceptable, particularly when the doctor has found that the third cartilage, cricoid cartilage, hyoid bone, tracheal ranges, and start muscles of the neck were intact. It is further argued that there are good chances of success in the case. Balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, placed the evidence of PW4 and PW7. Considering the submission made by the learned counsel for the respective parties, absence of any direct evidence, nature of circumstantial evidence adduced by the prosecution during trial, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. तमर बेल ହେଇଗଲା गरिला मनोहर राव. Yes. Yeah. That's a concluding paragraph. Which sum up absence of any motive behind the commission of the crime, and also the and since the parents of the deceased had gone for strike, that off कर दिया उनसे.
Pass over item number 4.
Yes, Sonita Biswal, not there. Non appears on repeated call of this matter, Louis commencing from 24th June 2024. हाँ कोटा मैं से काली काली डाकी बात करके ना ऑप्शन दिली काउंसिल ना तो ये जो उड़ा तो देशम की अन्य उड़ा तो फेर मैटर उड़ा सब टेस्ट करेगा.
Weekly list item number 1.
In that case, Mr.